the Section 31 of Payment of Bonus Act. What is Payment of Bonus Act? Actually, the Payment of Bonus Act has come in the year 1965, and Section 31A was inserted later in 1976. Why it was inserted? On those days, there are so many trade unions show their bargaining power with the employer to pay more than a bonus amount from the profit. Because of that, the 31A was inserted. Altogether, many of the companies used to pay bonus of customary bonus, interim bonus, and other productivity bonus and all. Section 31A inserted specifically for the purpose of to make an agreement between the employer and the trade union or the employee to specifically pay the minimum bonus. That is, minimum is 8.33 and the maximum is 20%. And above to that, whatever the amount paid by the employer to the employee will be treated as a ex gratia. That is very clearly said in the 31A section. Now, what was previously dealt with before to 1976? It is based upon the profit. There is no productivity and all. So, automatically, if an employee works in a company and they doesn't care about the employer is getting profit or not, but after insertion of the 1976, they specifically said that whether you are having the profit or not, the minimum bonus to be paid in the form of 8.33 and the maximum is 12% based upon the profits. So, subsequent to that or over and above to that, if production or productivity is dealt in different aspect. 31A specifically deals about allows for payment of bonus on the basis of production and productivity. There is a logical presumption that whatever there is a statutory payable under the Act would be basis of profit. And here, 31A specifically deals that production or productivity. The section applies only there is an agreement between the employer and the employee to this effect or not otherwise. So, the statutory bonus to be paid surely that cannot be neglected, but and over and above of minimum bonus to be calculated based upon their profit books of from the books of accounts, and that is to the great extent of 20%. And pre-amendment period, that is pre-amendment position, can be in the section 31 of section 7 subsection 7. It is renumbered in 31A under this section, and it is specifically for to make an agreement between the employer and the employee. That is the purpose of this insertion. And in the case of Bombay High Court in Petroleum Employees Union versus Industrial Court of Maharashtra held that the prohibition implicit in the section against the contracting out of the statute for the benefit of the employee and not in his detriment. Section 31A, an exception to this policy, permits the employee and the employers to alter the basis of bonus by linking it to production and delinking it from profits. Section 34 does not prevent the employer from paying to the employees anything not covered or contemplated by the Act. So, if an employee interested to pay bonus more than 20%, it will be treated as a ex gratia, and it will be based in the form of ex gratia, even though it will be from the way of production or productivity. That is clearly set in section 31, and that too they have to make an agreement. And in the case of Tikkanagar Paper Mills Company Limited versus its workmen, it's laid down the following 4 conditions that have to be fulfilled in order to attract the exemption under the section 31A. There must be an agreement or settlement between the employees and the employer. The said agreement or settlement must be the payment of annual bonus. The said bonus was linked with the production or productivity. The said payment was in lieu of bonus based on profits. So here, after paying the maximum bonus of 20%, if your books are often so much of profit, and you want to pay any amount of money more than that, and it should not be treated as a bonus. What you have to do? You have to fulfill the four conditions under section 31A. And we have to maintain the register under the payment of bonus act, as all of us knows about that. And over and above that, there is no limit how much they can pay. And section 11 of the act that deals with the payment of maximum bonus would indicates that any payment more than the upper limit of 20% would not be considered a bonus payment of bonus under the payment of bonus act. And entry bonus and the customary bonus that and all paid during the occasion of the festivals, and it can be adjusted, and it under the section 17 of the act essentially deals with those bonus payments made to the employees as customary for one instance. So it will be adjusted in the bonus, and how that will be treated as a interim or customary bonus. In the case of Graham Trading Company India Limited versus Workman, court laid down the following points. It should be on continuous basis. There is no interruption because of non-profit or something like that. And it should be continuous, and there is no intermittent data also. That will be treated as a interim or customary bonus that can be adjusted in the bonus act, and you should not pay lesser than the minimum wage, minimum bonus, like that it has said in the case law of Graham Trading Company versus its workmen. And also, I want to mention here that there is no clear-cut definition under the Payment of Bonus Act what is called bonus. So, there is no definition till date that has not been given even after 1976. But the Act very specifically mentioned that in so many case laws also we are referring the payment of bonus to be paid minimum of 8.33 and a maximum of 20% in case of profits. And if at all anything beyond you are paying, it can be paid as a production or productivity with an agreement with the employer and the employee, and need not to say that that is to be a bonus. So it will help the organization to get the more productivity and production. Thereby, the company earns a profit, and both the employer and the employee survive in future in a better manner. Thank you, and subscribe to my YouTube channel Murali HR. Thank you, and I will meet you with another presentation in future. Thank you.